No, no mentioning. Sure. Item number 1 with item number 2.
Lordship, I appear on behalf of the award holders. One small rectification, Lordship. On the last occasion, your Lordship had passed the order, but our names were not recorded.
Millets, I beg your leave to appear online, Millets.
Yes, the names were not recorded, so we are recording minutes.
Yes, my lord.
The names of certain counsel were omitted inadvertently in the order dated September 19, 2025. Full stop. The names are as follows and be deemed to stand incorporated in the said order. This order be treated to be a part of the order dated September 19, 2025.
Great line the date.
হ্যাঁ এই নামটা না যে নামগুলো দিচ্ছেন উনি এগুলো অর্ডারের বডিতেও থাকবে অ্যাজ ফলোজ বলেছি ওখানেও থাকবে আবার ওপরেও থাকবে ওপরে এদের নামের সঙ্গে আবার বাকি নামগুলোও থাকবে
Well, only same.
No, you give today's appearances separately.
Well, I am giving today's appearance separately.
Today's appearance separately,
and on that date appearance also. I have
names will also go in that days and today's also.
Yes, I have recorded. I have written that things on that.
In your list, give all the names which will appear in today's order as appearance separately,
And
including
on
this.
that date also, my lord, my appearance has been recorded in item number 3, not in item number 4.
What?
I am giving it.
এইগুলোই শুধু দেবে আর এই যেটা অ্যাপিয়ারেন্স স্লিপ দিচ্ছিল না সেটা আজকের অ্যাপিয়ারেন্স লিস্টে থাকে বোঝা গেল তুমি একটু বুঝিয়ে দিও এটা অর্ডারের বডিতে ঢুকবে আর এইগুলো নেক্সট
I am grateful, my lord.
থ্যাংক ইউ ভেরি মাচ
আরেকটা লিখে দে আগের দিনেরটা লিখে দে আর একটা লিখে
Item number 3, specially assigned matter top.
I'm grateful, man.
Grateful, Lord. Thank you. Yes.
Because this matter is appearing at my instance, I had mentioned last Friday.
Right.
I have served the other side as well, but I have served the other side through mail on the Friday.
What is this?
Till section 11, my lords. Now the issue is possibly, my lords, the other side wants to delay this matter because on the last occasion, in the month of June, there were direction for affidavits at our instance because they had sought time. The only
Yes. Yes. So there's a timeline in the statute also.
yes, my lords, and just this is very simple.
Without them, and there will be another recall application. That is the recall.
The issue is, my lords, my ground for mentioning also was that this lady is 75 years old. It's been filed and there are a series of litigations ongoing.
You have given a notice to Mr. Arindam Paul. His name was recorded anywhere to have been appearing for the other side.
Yes.
Because on the last occasion, we see the name of Ms. Shubhoshri Chatterjee appearing.
He had sought time, my lords, but I'm being instructed he's the advocate.
He's the advocate.
Arindam Paul.
Well, what is the matter?
The matter is essentially arising out of a leave and license agreement, which we had given to the respondents. It's dated May 2010. Now, 2017 disputes arose. I had proceeded in a suit. Now, in the suit, they filed a Section 8. The Section 8 was not allowed, but they came up in 227 before this honorable court. The Section
Definitely,
8.
yes.
Your Lordship, I'm led by Mr. Banerjee.
Right. Yes.
So the Section 8 was ultimately allowed in 227. So now, pursuant to the leave to approach this honorable court in terms of Section 11, I'm here. So, my lords, in principle also, I think they should not object to this.
They challenged.
They challenged
They
that.
sought reference and challenged that. when
Exactly,
it
my
was
lords, humbly. Now, my arbitration clause is at page 17, clause 24(9).
When was that leave ultimately given?
Leave ultimately, my lords, was given section 8, page 25 to just a second.
9th of November 2022. When did you file this section 11?
Yes, this section 11 was filed November 2024. I should be candid before your lordship. Before this, another section 11 was also filed.
What happened to that?
That was disposed of because we had submitted talks of settlement are going on.
So that does not.
So there isn't any issue.
Settlement has failed.
Settlement has
Have
failed.
you stated about that in this?
Yes, yes,
Very
yes, my lords.
Yes, what is? Will refer?
Yes, Your Lordship, I was praying for a short passover.
No, passover. Last day, no passover. So who should be the arbitrator? What is the valuation? An advocate or a judge?
My lords, advocate would suffice because the rent of the premises perpetually was around 40,000.
Who is leading you?
Mr. Banerjee.
Which Banerjee? There is
Mr. Rohit Banerjee.
Rohit Banerjee. So you agree on an arbitrator, the name of an arbitrator. I'll make it official. I mean,
I would require instructions from them.
if you have not got instructions even after notice, then Either God or arbitrator may help you. Whichever one we believe more.
And the claim perhaps would maximum be around 35 lakhs in total.
35
I think.
lakhs. All of whom I can think of are very busy.
It's Mr. Shashwat Nayak if it so commences. I mean, since the claim amount is low.
Shashwat Naik. Yes, you can appoint Mr. Shashwat Naik. Very well. The dispute arises, the present application under Section 11 of the Arbitration and Conciliation Act 1996 arises out of a dispute within the contemplation of an arbitration clause, comma, bearing clause 24 within bracket small Roman 9 bracket closed, contained in an agreement for leave and license between the parties dated May 19, 2010. Full stop. Upon the dispute having arisen, comma, a suit was initially filed by the present petitioner, full stop. In the said suit, comma, an application under Section 8 of the 1996 Act was preferred by the respondent, which was turned down by the learned trial judge. Full stop. Thereafter, comma, a challenge was preferred before this court. 227 is maintainable.
That's it.
Your Lordship, I've been instructed that the settlement is still ongoing.
It will go on. I'll leave it to you to approach the arbitrator and say that also. Having turned down.
Kindly, Your Lordship,
trial
if
judge,
last chance.
please. Preferred before this court by way of CO 1693 of 2019. Full stop. By an order dated November 9, 2022, comma, a learned coordinate bench of this court had allowed the said revisional application, comma, thereby allowing the application under Section 8 of the 1996 Act filed by the present respondent. Full stop. Thus, comma, it is submitted, comma, it is submitted by learned counsel for the petitioner, comma, there cannot be any objection in principle on the part of the respondent to the appointment of an arbitrator. Full stop. Subsequently, did you give a notice?
Yes, my lords. The last notice, section 21, is at page 45, 19th November 2024.
Very well. Subsequently, notices were given for appointment of an arbitrator by the present petitioner to the respondent, comma, lastly on November 19,
page 45.
2024. Full stop. Next para. However, comma, no consensus having been arrived at between the parties regarding the arbitrator to be appointed, comma, the present application under Section 11 was filed on January 9, 2025. That is, beyond the statutory period of 30 days after the request was not considered to. Which of next para, it is further submitted by learned counsel for the petitioner that a prior application under Section 11 of the 1996 Act was disposed of in view of there being an imminent chance of settlement then between the parties. Full stop. However, comma, such settlement having not been fructified, comma, the present application had to be filed. Full stop. Next para. In view, upon hearing learned counsel for the parties and consideration of the above circumstances, comma, this court is of the opinion that there cannot be any further impediment in appointing an arbitrator, comma, more so since the respondent itself had sought for reference to arbitration and the dispute among the parties comes within the ambit of the arbitration clause and is otherwise arbitrable. Full stop. Accordingly, AP3 of 2025 is allowed, comma, should I record on contest? Because this is a talk of settlement. Allowed, comma, thereby appointing Mr. Shashwat Naik. Please give his phone number whenever you can. Either if you can give the phone number of Mr. Shashwat Naik. Shashwat Naik, comma, an advocate practicing in this court, comma, as the arbitrator to resolve the dispute between the parties, comma, subject to a declaration being furnished by Mr. Naik within the contemplation of Section 12 of the Arbitration and Conciliation Act 1996. Full stop. The remuneration of the arbitrator shall be fixed by the arbitrator on consultation with the parties within the contemplation of the 1996 Act and the schedules thereto. No address to cost. Much obliged. শাশ্বত নায়কের পরে ব্র্যাকেটে ফোন নাম্বার হবে, ওনারা দিয়ে দিচ্ছেন। প্লিজ গিভ দ্য ফোন নাম্বার অ্যাজ
I have already handed over.
জাস্ট ইন এ লাইট slip
I have
of
already
paper.
handed over.
Item number 4,
Yes.
contempt matter, Electro Steels Castings Limited.
I appear for the petitioner. Well, this is that matter, Lordship would recall, where numerous adjournments were taken on the view of pendency of an appeal.
Yes.
Now that appeal is dismissed for default. Now there is no impediment in proceeding with the contempt.
But WBITC has filed a restoration application.
Maybe.
But
We cannot. This is dilated act. Sorry, you have to comply. Will issue rule.
allow me 2 minutes.
When was it dismissed for default?
9 September. It is not 30 days has also not passed. Can you allow me 2 minutes, Manoj? There is a new development, Manoj, to kindly consider. Manoj, by this statute, Manoj, all incentive schemes has been revoked. All incentive scheme has been revoked and it has been also been mentioned. But kindly, Manoj, just
When you did not come, when the order was passed, it was
No,
ceased.
no, Manoj, it is says it cannot be enforced.
We cannot reopen our order in contempt.
Manoj, I am
No,
only
Mr.
saying
It's very settled.
whether it can be a defense or not. I'm only saying this. Whether kindly consider this section.
Were you directed to file your opposition?
Then we have to file an
Did
opposition.
you direct you to file opposition?
When the rule was issued, they have answered the rule.
They have answered the rule.
We have filed our reply.
Then Manoj, we
then
have to
This,
file a
this
opposition.
point was not taken.
No, Manoj, that was not there at that.
For personal appearance, they are personally appearing.
There
There was a direction for personal that has been dispensed
But
with.
only kindly
No,
consider.
no further defense at this. Sorry.
Manoj, at least give me a minute, Manoj, thereafter Manoj passes that. Manoj, kindly come to section 4, subsection 4. I'll be, Manoj, on this premise, at least I am entitled to an opposition or not, kindly consider. Notwithstanding anything contained in any other law for the time being in force, no suit or other proceeding shall lie or be maintained or be proceeded with or continued any court before any tribunal or authority for claiming any incentive and for payment and or refund of any incentive under any schemes or grant or obligation, and no enforcement shall be made by any court, tribunal or authority of any judgment, decree, order, arbitral award or direction of any authority directing payment or refund of any benefit.
Challenge the virus, Mr. Ali.
It has been challenged. 10
We have,
Will take
we
1
have
minute
filed a
to set aside
petition
this
challenging the
virus.
virus.
this has been
Ridiculous. You are going to extend, Mr.
Manoj,
I mean, this is ridiculous. Your client should, I mean,
Manoj, it has been challenged.
your client just to avoid contempt, you are, I mean, going to ridiculous extents.
Our point is, Lordship,
We are
this
very sorry for this. And this came after this.
contempt proceedings cannot be, Lordship.
Manoj, subject to correction.
When the order was passed, this was not there.
Kindly consider this.
You cannot take away the effect of contempt.
Subject to correction. Then allow me to file an opposition. Manoj, put this.
No further opposition. Sorry, rule has been answered. What
No,
opposition?
rule has been answered. There is an appeal was pending at that juncture.
Maybe appeal was. Pendency of appeal does not opposition.
This,
No.
But there has been
No.
a challenge also. But there are the companies have come up and challenged this.
Maybe.
The direction for affidavits, obviously, there cannot be interim orders.
No question of affidavits. What affidavits? After rule has been, you have answered the rule.
But today, kindly consider this. This is a dismissal. This was not dismissal, and it was 1 odd days.
We'll adjudicate on this. We'll direct your clients to be present on the returnable date and send them to jail.
But kindly allow me 1 minute thereafter, Manoj.
We have given you 2 minutes. You asked for 1. We have given you 2. Sorry.
Manoj, just 1 minute.
Learned counsel for the petitioner submits that repeated adjournments had been taken by the alleged contemners on the
this is
ground
not correct, Manoj.
of
Manoj, kindly see
pendency.
the last.
Please. On the ground of pendency of an appeal against the impugned against the order under contempt. Full stop. Next para. Such contention is controverted by learned counsel for the alleged contemner. Full stop. Next para. However, comma, even from the previous orders passed by this court go on to indicate that at least on 7 prior occasions, comma, an adjournment was sought on the ground of pendency of the appeal. Full stop. Next para. Learned counsel for the petitioner hands over a server copy of an order dated September 9, 2025, whereby APOT 5 of 2025, comma, the appeal preferred against the order under contempt was dismissed for default. Full stop. Next para. Learned counsel for the alleged contemner, comma, however, comma, seeks to rely on the revocation of West Bengal incentive schemes and obligations in the nature of Grants and Incentives Act, comma, 2025, comma, which was apparently published and notified in the official gazette on April 2, 2025, comma, that in terms of section 4 thereof, comma, notwithstanding anything to the contrary contained in any judgment, comma, arbitral award, comma, decree, comma, order or direction of any authority, comma, court or tribunal, comma, the state is capital, state government is G capital, and stroke or its authorized agents, A capital, shall no longer have any past, comma, present or future liabilities or obligations under the CAPSE West Bengal incentive schemes and stroke or under any G capital grants and O capital obligations, comma, of any nature whatsoever, comma, or for any capital I incentive under any contract or agreement or promises or any law of the state legislature is L capital. Full stop. Next para. It is submitted that in view of the operation of section 4 within bracket 1 of the 2025 Act, comma, the contempt has been rendered infructuous, comma, since the order is no longer operative, comma, having been overridden by the provisions of the 2025 Act. Full stop. Next para. The court will be failing in its duty if it does not note the patently recalcitrant attitude of the alleged contemner. Full stop. Next para. After having sought adjournment on numerous occasions, comma, from prior to the enactment of the 25 Act till much thereafter, comma, at this stage, comma, the alleged contemner seeks to rely on a statute which has been promulgated on April 2, 2025, comma, that is much subsequently after the order under contempt was passed and the contempt proceeding was even initiated. Full stop. Next para. The promulgation of the said act was never urged as a defense in the contempt application, although rule was issued and a show cause was filed in pursuant thereto. Full stop. Next para. Rather, comma, the common refrain in all the adjournment prayers of the alleged contemner has been, comma, till date, comma, that an appeal was pending. Full stop. Next para. However, comma, the said appeal itself was dismissed for default, comma, thereby bringing to light the deliberate ploy of the alleged contemner to protract litigation under one pretext or the other. Full stop. Next para. Even if the 2025 Act has been enacted with effect from April 2, 2025, comma, clause 4 within bracket 1 of which seeks to erase the effect of past orders of any court or tribunal, comma, it is well settled that within the contemplation of the General Clauses Act, comma, such retrospective effect cannot be given to accrued rights under an order of court. Full stop, next para. It is to be remembered that the contempt jurisdiction is not restricted by the Contempt of Courts Act, but flows from the powers of a court of records stroke constitutional court under Article 215 of the Constitution of India, and is an inherent power of the court to ensure that the rule of law is maintained. Full stop, next para. Even if the 2025 Act is taken into account, comma, the same cannot nullify the effect of a contempt application retrospectively. Full stop, next para. The contempt proceeding was initiated at the stage when the 2025 Act came into force. Full stop. Even without going into the merits of the challenge to the virus of the same, which learned counsel for the alleged contemner submits have already been preferred, comma, it is palpable that if the order in question was at that stage, at the stage of implementation, and no contempt had been filed, comma, there might still have been an arguable case as to whether the said order has been rendered toothless by the 2025 Act. Full stop, next para. However, comma, once the order culminated and ripened into a contempt proceeding, comma, it is between the alleged contemner and the court, and for the alleged contemner to show as to what prevented the alleged contemner from complying with the order, comma, passed much earlier than the promulgation of the 2025 Act, at least between the period from passing of such order and the enactment of the statute. Full stop. Hence, comma, even if the 2025 Act or its virus is upheld by courts, comma, fact remains that the act of deliberate and willful violation of the order of this court prior to the 2025 Act coming into effect on April 2, 2025 cannot be purged by any means whatsoever. For sub next para, since now in view of the above, comma, this court is of the opinion that penal action should be taken against the alleged contemner, full stop. Accordingly, the alleged contemner shall remain in court personally on October 31, 2025 at 10:30 a.m. when the matter shall next be listed for passing orders, appropriate orders.
May I just one prayer?
My lord,
Nothing.
Well,
Next.
1 week extra, my
my lord,
lord.
one,
Nothing.
my lord,
Next.
may I? My lord, may I? My lord, there was two appeal, my lord, both are dismissed for default, my lord.
We have taken note of one. Yes, next.
I'm grateful, Lord.
May I say one thing? No, nothing in defense. My lord, last day before puja.
Let her go to jail. Mr. Chakravarti will ensure that she suffers.
saying
Will
this.
ensure. Your action, the state action, Mr. Chakravarti,
I have-
we are very careful to see that we do not traverse into the jurisdiction of the other wings of the government. But this is travesty of justice, Mr. Chakravarti.
my lord, what-
Just convey to whoever is concerned, whoever 2025 Act comes, so many contempts pending, and you try to efface the act, the previous actions of contempt. Contempt cannot be purged.
my lord,
That's my specific view, at least between the period of enactment of this act. You try to steal a march over courts. Mr. Chakravarti, courts know how to defend the rule of law. Courts very well know, and I am confident that we shall put her behind bars, or she'll be penalized with contempt action, the penalty for contempt.
that is between the contemner and the court. I will not come in.
Don't stand in between. Yes, the matter is over, Mr. Dutt. Next.
Item number 5,
Yes.
Kolkata Metro Rail Corporation Limited.
নতুন অ্যাপ্লিকেশন হয়েছে ওটাই তো ইয়েস হ্যাঁ থ্যাংক ইউ ইয়েস প্লিজ We'll take up to 12 today.
I'm sorry, my lord.
We'll take up original side matters up to 12 today. So, yes.
Then I'll come back at 12.
No, up to.
Oh, up to. I thought after.
No,
12,
no,
my lord.
up to. We have curtailed it from 2 to.
My lord, everybody is my lord, before starting, my lord, this is why you should not, my lord, talk too much. For the last, my lord, 2 vacations, I have been telling people that evening we go on a vacation. Now I've developed a habit. Last day, nothing happens. I go and play golf.
You play golf?
Yes, I proudly tell people I take 3 friends and go and play golf. I make them all take vacation, holiday leave because they are not working elsewhere. They have to take leave.
Oh, they're from other fields.
Other field, not from the
That's-
profession. Now, my lord, I proudly tell people this that I last day I don't go, and look what has happened this time.
Yes. So the golf starts from the morning.
Yes, 9 o'clock.
So you will ensure that you go to the golf course quickly. So
Yes, I'll finish and run away. But I wanted to finish this because again, to be very honest, I didn't want to take a chance. 30 days, my lord, after your lordship's vacation, with your lordship sitting at home, the good possibility your lordship will start dictating.
Definitely.
I know that's
But we
why
will
I
do for
want
the
to
30
finish.
days. Not even 30 days now. 3 weeks probably. And there's a break and then. Now you have curtailed it.
That's why.
That's too much of a time to sit at home.
It is impossible.
Impossible.
After
Your-
10, 12 days, you start
Your family
thinking,
members will turn you out.
yes.
You get
Well, by the-
irritated and
by
irritable.
the end of vacations,
Yes.
the most happy people are the family members when court opens.
Yes. Like
I-
like school children. I mean, their mothers are very happy when school is open.
Same. I
So
have
our wives and whoever is there, they are also happy when you come to court.
when you
God knows what will happen after 62.
that's very daunting thought, Willard, to
Very
wake up and
daunting.
have nothing to do.
That is the worst possible thing that can happen to others.
I keep
to at
telling
least-
myself I have to keep fit so that that day doesn't come that I can't come to court for health or physical reasons.
That is one aspect of the matter, Mr. Chaudhary, and the mental aspect is all the more excruciating. I mean, during COVID, just see what happens to us mentally also. Sitting at home after full-fledged work.
It is very
sitting
difficult.
Suddenly, I mean,
Very difficult. I know nothing else to do.
no, I also.
Nothing else.
Reading, how far can you read on and on and on?
No. You can't
Other people's knowledge.
read. Netflix I have finished during
Netflix,
COVID,
and soon what happens, Mr. Chaudhary, when you start the movie, you know the end.
and you
That
get
happens
bored
to you
also.
when you are in this profession.
Yes.
I'm telling you. The movie starts and you get the plot and know the end.
Only,
That is what happens to advocates and judges.
only 2 things I
You
know.
are trained to do that only.
Only to predict.
Yes. Only to predict.
And the other 2 things I know, one is squash, the other is golf. Squash is gone almost. I'm 48.
No,
Golf will also go in some time because I am too old, Millard.
you're not too old for golf.
No, but it takes a toll on you. You can't play at a good level.
No, good level, forget good level. Maintenance level, yes.
Yes.
I also have my other,
Yes.
but that is the only thing I have. Apart from reading, music, after a point, I lose focus now.
We know nothing
I
else.
lose
Our
interest in
lives are
everything.
spent here.
No, nothing else. That's very
Nothing
difficult.
else. I see Mr. Anindo Mitra. Millard, he just loves his work.
Yes, absolutely. That's available to advocates. I mean, to judges.
Even today, if he's not gone off, I don't know because I wasn't there. If I go to him at 2 o'clock in the afternoon and tell him, sir, will you please settle a written statement?
He'll be very
agree. He'll happily do it. I have seen him up to 1 o'clock settling a draft and leaving home at 1:30 for a 30-day vacation.
Wow. No, my grandfather stopped work and he was an advocate, so he expired soon after. But we force our father. We don't force. He goes by himself to court.
Yes.
Court
he
has to be. He has to be in
has
court.
to go to court.
Whatever happens.
Millard, I want to come to court till the day I leave.
I want
That
it.
is an ambition. You, Lordship, now has
Wanted.
chosen.
Yes.
Now,
So let
Millard-
us get it over with.
Yes. Now, Millard, the on the aspect of
Will it be over today?
yes, I'll finish.
So can we take written notes of arguments today?
Yeah, I'll Millard finish it by 4 o'clock and submit it.
During the course of the day, yes.
Yes.
And you can also file your written notes today.
They've already filed. No,
You had.
No, we have not filed in it.
Acha, very good. So
We have not.
try to file today if you can't, if it's ready. Otherwise, if you can't file, I'll give you my email number, email ID, so that you can, both of you can send within, I'll give you a time within that period.
Yes,
Then we'll also do
that will
that.
be of great help, Milord.
I'll do that. I'll give my email ID, and then on a slip of paper it will be circulated to you, and just you
We'll
can
mail
send it
Milord.
within 7 days. Please do it
Yes,
at least.
Yes. Then I can.
Kindly allow 10 days because Saha is not here. He will be coming back, and I have to.
Why 10 days? You must have it prepared already.
No, it
You
is
know your.
already, it is ready. It is ready. But only thing I have to take some advice from him in case he has got some point.
Whatever time your lordship gives, I have, Milord, I
Whatever.
never.
So let us finish it
Yes,
formally.
Milord.
Yes, Mr.
Milord, because I think, Milord, there are two aspects of the matter, three aspects of the matter. One I have exhaustively covered. And in fact, this was the only aspect I had started off in my opening submission. The first aspect is non-consideration of over 5,000, 10,000 pages of evidence. Second aspect is the decision, the findings of the learned arbitral tribunal that the general consultant is responsible. I looked at it very objectively. When I saw the award yesterday, I read it again and again. They don't say that the GC is responsible. They say, the learned arbitral tribunal, Milord, says that GC could not predict. Number one. Number two,
GC could not, sorry?
GC could not predict the incident. Number two,
yes,
we have not gone into an inquiry pertaining to the GC. Since GC could not predict and we are shielding the GC, therefore, this is an unforeseen event.
all right.
Now, my lord, for the learned arbitral tribunal to hold against me, they have to hold that this is unforeseen physical circumstances which has caused the incident. When that happens, we go into the realm of, my lord, the damage lies when it falls and insurance pays for it. Otherwise, they are responsible. That's the contract. So, my lord, this is, my lord, the sum and substance of the second part. Now, apropos this, I have got, my lord, three things to say. Number one, the clauses of the contract cannot be, my lord, washed away and have to be considered by the learned arbitral tribunal. The clauses, my lord, I'll show just three clauses of the contract, four clauses in fact. My lord, kindly see GCC 14.3, 14.5, 15.2 and 15.3.
What will be the page number?
My lord, this is contract is given separately.
Oh,
my lord, before I, my lord, show these four clauses, role of GC, my lord, two submissions again. Number one is an example. I'm going to make a house. I engage a civil contractor. Civil contractor will also have an architect. I also engage X, who is an expert in making houses and who also has architects. The design, the plan, the method, brick on brick, so much of concrete, etc. This will be prepared and submitted for my approval to the GC. When GC approves, that's my approval. So what does the GC approve? Number one, GC approves the method. Number two, GC approves how it is to be done, as in the TVM. Is it appropriate? GC approves that. Number three, GC will go look and inspect. This, my lord, is the GC's task. Now, my lord, this building is, my lord, all method statements, plan, everything given to me. GC approves it. When they make the building comes crashing down. Now the contract between me and the contractor says that anything which happens regarding construction, contractor is liable. It's, my lord, what is known as a design-build contract. Contractor designs, I approve, contractor builds, contractor is responsible A to Z, everything. The arbitral tribunal holds that just because you had appointed a GC, contractor is not responsible. GC is responsible.
So you say the GC's role was not to execute.
Not to execute. What is the contractor's role? Design, get it approved.
And you also said that if that argument is accepted, then in no case will the contractor be liable.
It turns the contract upside down, and it effectively, in the world of contractual adjudication, an expression is often used, court is rewriting the contract. So effectively, those clauses, the 4 clauses which I am now going to place, will be obliterated and effaced, my lord, immediately by, my lord, the judgment.
So the same thing which happened to the TBM will happen to the contract.
Happen to the contract.
If you rewrite.
Yes.
It will go sideways.
And TBM happened, my lord, because they didn't have brushes. Contract, it will happen because of, my lord, the learned tribunal's decision and the reasons given. Now, my lord, may I just show 14.3, 14.5.
Just quickly let us go through those. Quickly let us go through those.
The clauses. No, I'll just
indicate. Then contract.
Contract.
Just ask the learned.
Contract.
Somebody can come this side also.
Contract Part 2.
What will you be relying on apart from the contract? Anything else? Then that can be sorted out by some of.
Yes, we have made a chart and given it exact volumes which we will need. করে দিয়েছে তো আপনি? না ওটা করে চারটা করে কাগজ একটা দিয়েছে না?
বড় এটা ডেমি A4 বা ডেমি A4 হলে ভালো।
দেখুন গুলো লেখা আছে। এই যে এখানে ভলিউম গুলো লিখে দিয়েছে।
ওইটাতে হবে না। Put it on a better paper. I'll definitely lose it. There's no
No,
doubt.
I thought for him to take out, that's why we just... Yes.
Oh, yes, that will do.
Yes, and Milord, I'll make a sheet.
Which may be the anchor of the.
Yes.
Yes, Mr.
Whatever both sides have relied
Right,
upon, I'll, Milord,
thank you so much for that. Yes. So 14.3 first.
Yes. Milord, this is under risk and responsibility. Milord, please also see 14.1. Contractor is indemnifying and holding me harmless from all claims.
Yes.
Damages, losses, expenses, demands, everything, all nature and description, by reason of any act or omission of the contractor, his responsibility, the employees. So everything comes, he indemnifies me. Then, my lord, 14.2, contractor's care of the works. He'll take full responsibility for care of the works.
Yes.
Full responsibility for the, this is a misprint, my lord, cafe of any work being manufactured, sold, etc., everything. Then, my lord, 14.3, employer's risk. Employer's risk of loss or damage to physical property in India and of death, personal injury occurring in India in consequence of performance of obligations under the Contract Act. My lord, war, hostilities, then, my lord, rebellion, riot, radiation, pressure waves caused by aircrafts, use or occupation by the employer of any part of the works. That's all. Then, my lord, 14.5. Contractors' risks are all risks other than employers' risks, as given in 14.3. So, indemnity and everything else. Now, my lord, the next. Please see 15.2.
Yes.
Insurance for works and contractors' equipment. Contractor shall insure plant, material, works, in the joint names of the employer, contractor, and subcontractors available against all losses or damage. Insurance shall cover loss or damage from any cause other than employer's risks as per 14.3. Full replacement cost. So, my lord, it's put on the all contractors doing the work. It's his design, his execution, full liability on him, and he will insure himself. So that, my lord, if he, my lord, goes bankrupt for any reason, I'll get it from insurance. So, my lord, the contractor employer is covered. Unless he does something, which is, my lord, 14.3. 14.3F is use or occupation by employer of any part of the work. So if I actively do something, occupy, then I won't make him responsible. But otherwise, everything else here, and the rest of it is, my lord, rebellion, war, all of that is not likely to happen. So that's, my lord, the contract. Now, my lord, GCC, I'm sorry, my lord, that's 3.2. My lord, please see 3.2 now, my lord, which is in this volume.
Yes.
My lord, at page
Got it.
14. My lord.
000.
Yes.
Yes. 14.
The 3.3 is engineer. 3.1, employer shall notify the contractor in writing of the appointment and identity of the engineer and of any replacement from time to time.
This engineer is a GC.
Yes. Then the engineer shall carry out the duties specified in the contract. Engineer shall have no authority to amend the contract. Engineer may exercise the authority specified in or necessary to be implied from the contract if the engineer is required to obtain specific approval of the employer, he shall do so. Then, my lord, next is engineer shall have no authority to relieve the contractor of any of his duties. Any proposal, inspection, examination, testing, consent, approval, or similar act by the engineer shall not relieve the contractor from any responsibility, including responsibility for his errors, omissions, discrepancies. And engineer's authority, delegate, etc.
But 3.4 was heavily relied on probably. 3.4.
3.4, my lord, is engineer's instructions.
Yes.
Contractor shall comply with instructions given by the engineer in accordance with the contract. The contractor shall give reasonable notice to the engineer of instructions which he considers necessary to enable the engineer to issue instruction. Engineer shall not be bound.
But the next paragraph is no act or omission.
No act or omission.
That is very crucial. That is relied on by.
No act or omission by the engineer or the assistants to the engineer in the performance of any of the engineer's duties or the exercise of any of the engineer's powers under the contract shall in any way operate to relieve the contractor of any of his duties, responsibilities, obligations, or liabilities imposed upon the contractor by any provision. This is clear. All these clauses turn on their head. Now, my lord, also one more clause, SCC 4.9. Same volume? No. My lord, after this is the special conditions of contract. Yes, at page 73, 79. Same volume, my lord.
GCC 4.9.
Yes.
Now, my lord, please see this, my lord. Geotechnical and other related data provided by the employer are based on investigation conducted by KMRCL and for reference purpose. Tenderer should satisfy himself with the data furnished and make his own investigations if required for submitting his offer. Any change in design or construction methodology later during execution on account of change will be borne by the contractor. Contractor shall not be relieved from any risk or obligation imposed on or undertaken by him under the contract on any such ground or on any ground that he did not or could not foresee any matter which may affect or have affected execution of works or compliance with his other obligations under the contract. My lord, this is for soil. His case is, my lord, soil. Now, my lord, 4.23 in the GCC, which is the plank of his submission. My lord, this is unforeseeable physical condition. My lord, this is his case. This is not to do with soil. In this clause, physical condition means natural physical.
You are reading.
My lord, 4.23 GCC, page 27.
Yes.
Unforeseeable physical condition. In this clause, physical conditions mean natural physical conditions which the contractor encounters at site while executing the works, excluding climatic conditions. Natural physical conditions. If during the execution of the work, the contractor shall encounter physical conditions which, in his opinion, could not have been reasonably foreseen by an experienced contractor, contractor shall forthwith give written notice to the engineer, and if in the opinion of the engineer, such conditions could not have been reasonably foreseen by an experienced contractor, then engineer shall certify. My lord, natural physical condition, maybe rock, maybe something else. And no notice given under this clause within the time.
Why shouldn't this be natural physical condition? Although no certificate was issued.
This is soil condition.
Yes.
So soil condition is dealt with separately. For soil condition, KMRCL has geotechnical investigative report done by my lord borehole tests.
What could be the scope of operation of this then?
Maybe a rock condition. Maybe, my lord, this has been used elsewhere in the contract. There is an example. Electric cable. No, that's not the right
Physical.
Physical obstruction, sewerage line,
there are many, my lord, physical obstructions.
No, natural physical condition. Why shouldn't it include soil?
Really, my lord, it's really, my lord, maybe rock, maybe something else, maybe
if rock, then soil is a ground form of rock, basically.
Yes, but my lord, I want to make a distinction here. This is not natural physical condition which is encountered at site. This
absolutely fits the.
This is, my lord, something you encounter. Maybe water table.
Yes, water table.
Maybe an aquifer. Maybe a rock. Now, my lord.
So encounter has to be there.
Yes. So I come across something.
That element of surprise.
Yes, I come across something. Maybe an underground lake. Maybe underground aquifer. Maybe underground water table. Maybe rock. Maybe something else. Now, the other side is the general condition of the soil is such that, my lord, it's clayey silt and water percolates. So that's, my lord, generally a soil condition. That's the general condition of the soil through which water passes. His case is the general condition of the soil was such that we cannot rule out the possibility of there being an artesian condition. Our answer, my lord, is again to go back to the reports by looking at the soil that no, artesian condition is not possible. That is the condition of the soil for which large data given and no consideration. Exactly the opposite finding. But this is something else.
Yes.
Now, simple, Milord, the other clauses.
You touch your points, Mr.
Yes, yes. Now, the other clauses don't permit, Milord, his responsibility to be obliterated. In the course of the arbitration, one of the learned arbitrators one day says that, where is your contract with the GC? Because I must have entered into a contract with the GC. We produced the contract. It's not on record. We knew what was coming. But in deference to, my lord, the arbitral tribunal's disclosure, we produced the contract. Now that contract is at volume 78. My lord, if your lordship sees,
Contract. Not only LTD, this covers the entire
this, my lord, this GC, ITD, I'm sorry, the GC is for all contracts of the KMRCL, not just this contract. Now, if your lordship sees, my lord, 12317. Lord, I'll be very, very brief and show the worst clause against me only. 12317.
Yes.
Objective of this contract is to obtain general consultancy services for procurement, construction, testing, commissioning, etc. So, my lord, if I between 12317 and 12328, your lordship can take it from me that the GC is to, my lord, give consultancy and, my lord, approvals, etc. for design, everything, for the tender document, tender conditions, design, everything. Ultimately, when it comes to, my lord, performance of the work, my lord, 12328. My lord, it starts from 12327. 3.6 supervision and monitoring. This is not contract between us. This is with me and GC. Now, this is what is relied upon in the award to hold me responsible. My lord, please see 3.6 site visit. To undertake visits to the construction site, monitor contractors' activities, etc. Now this is what is relied upon. To monitor contractors' activities with goal of minimizing adverse effects on public safety. Monitor. 3. Inform KMRCL of findings. During performance, this is their job. Now, when it comes to, this is what I have with GC. Now, when it comes to the contract between me and him, I liquidate it. And, my lord, it becomes for this contract, it is my lord, to look and see. Cluster bar kore daও. Look and see. Just.
Does your contract with the GC have any penal clauses? If this is not followed, then what will be done? Just I'll check up.
Yes, my lord.
Terminate the contract of
I can terminate.
page 5.
My lord.
78.
Page 78. Now, when it comes to, I have a contract with GC.
The 78 of your contract.
My contract, my lord. My lord, I have a contract with GC where I call upon him to do 20 things. Now, when I enter into a contract between me and him, in this contract, what do I say? My lord, please see 78
So
now.
you may haul up the GC under your
That's
contract.
my problem with him.
At the same time, they may not.
They can't escape responsibility. That's the contract. My lord, just one clause, my lord, page 78. I dilute it for our contract. My lord, shall watch, my lord, 2, subclause 3.2, functions of engineer. In addition to the duties mentioned in 3.2 of GCC, shall watch and inspect the works. This is like a person doing the work, saying that I wasn't supervised, so I'm not responsible. Using this logic, my lord, in no case can no contractor be held responsible.
So that would probably be hit by privity also.
Yes.
Probably be hit by
Now, my lord, quickly, in the next 10 minutes, my lord, I'll take your lordship through the award. My lord, I have shown your lordship, he's not, the arbitral tribunals not considered the whole body of evidence. Now, my lord, see from page 111, my lord, internal page 77 of the award.
award
Sorry?
data.
আসছি আমি। My lord, assessment by the arbitral tribunal. They start on a wholly wrong premise. What is the issue in the matter?
You have placed this. Did
No,
not
just
place
just
entire thing.
my lord, yes, I have placed it, but just my lord, paragraph
The
100.
arguments you place the entire thing.
I won't, my lord, place the entire thing. Just paragraph numbers and I'll proceed. My lord, 111.
Yes.
The arbitral tribunal gets the issue completely wrong. A, assessment of the causes of
Mr.
failure.
Chaudhary, you are re-arguing the
Very
entire
well.
thing. Don't re-argue.
Let me,
You have made your arguments at length and they have replied. So just
so my lord,
whatever you have to reply on their points.
so my lord, they have argued mainly on
I have
GC.
taken my mark the relevant places.
Correct, my lord, correct. So my lord, may I then not read
No, need not.
from 111 anything up to actually I've read the whole thing.
You had, and I have taken extensive. I've marked
Yes.
extensively.
My lord,
Fine. Obviously,
I-
you have your color is there, red. So it's
my lordship uses different colors for different
yes.
petitioner.
If it's state versus and or central versus, then I use particular colors for the state and the center. Actually, I do that. I have those colors. I mean, this is for center and there is another color for state. If it's a private party, generally pink or yellow, neutral
No,
colors.
it is.
It's easier to remember actually quickly. So when I go to the
my lord,
voluminous documents, you take the document and you find the green and the orange and the blue, pink, and you know who is it. But
it's a interesting first time in my life. Serious contest. I had to deliver a judgment. Most interesting.
which one?
I had to, my lord, in an arbitration,
Yes.
deliver a judgment. Very interesting. To deliver
When?
recently, my lord, 7
Or
days
you
back.
say generally, to
Generally,
deliver a judgment.
as an
Yes, yes, you get
experience
to
for a
understand.
lawyer, very interesting.
Absolutely. But the preparation is in vain from our viewpoint. Your preparation. Yes.
No, no, my lord, it's a good experience.
For you, from our viewpoint, I said. Yes, Mr. Chaudhary, please continue.
Now, my lord, I'll just only say this. When the GC's evidence, I'll just make 4 bullet points and stop on the award. My lord,
You actually had, I mean,
I have.
extensively.
So may I just sum up in 4 points and just stop it?
Yes.
Number 1, when the GC's evidence, which is my evidence, comes up, it's ignored on the conclusion that I'm trying to shield GC. GC report comes later. GC is biased. But you have to consider my evidence. He's my witness. Hard facts and figures, theories, documents can't be ignored this way. Number 2, these clauses which I showed your lordship, these are ignored and not dealt with, and GC contract is dealt with, and I am supposed to be biased. I'm shielding GC, and so therefore this whole thing is not irrelevant. GC is my special. Of course, my person has given evidence. What is so wrong in it? That's my right in a judicial proceeding. And lastly, my lord, there's very interesting observation that if GC could not, GC is full of experts. If GC could not predict, then why should the contractor be held liable? The contractor also could not predict, since GC could not predict. And so this is what is the award.
But that is contrary to the contract also.
And this contract, my lord, is what the learned arbitral tribunal had to see, and it is, my lord, look and see, look and inspect, etc. What is there in the GC contract is irrelevant. For this contract, I've read it down, and There's no requirement. That's not, there's no privity, etc. And ultimately, that paragraph about theories and theories. So really speaking, if one looks at it very objectively, there are two sentences in the whole award, or two, not two sentences, two, Millard, places, two, three places. The two topics. One is IIT Madras photographic evidence, which I explained. Extent of brushes is the only thing. The other is that quality of soil is such that there could be such a situation.
Quality of photographs and quality of soil.
Quality of soil.
These two qualities are
Yes.
important factors.
And quality of soil, in coming to the conclusion, all evidence is, my lord, disregarded. Only reason given is I am an expert. Same, my lord, learned member of the tribunal is the expert. So that's the only reason given. Now, my lord, something I did not spend time on the opening, and I also won't, my lord, spend too much time on, is claims. Just, my lord, the way claims have been awarded.
Page 91 of the award.
That's at, my lord, page 91 of the award.
Para 127.
Now, these are, the learned tribunal has held that these are unforeseeable physical circumstances.
Yes.
Learned tribunal has also held that no one is responsible. Learned tribunal has also held that we should cooperate and get this money from the insurance company. In this background, there is no reason for the learned arbitral tribunal, and none have been given in the award, for the conclusions that when it comes to my claims, I should go to insurance, and when it comes to my learned friend's claims, he should, my lord, come to me, largely.
All right.
My lord, I'll give a list of the claims. I have prepared it, I'll include it in the note. I'll give a list of these claims where I have to go to insurance, but he has to come to me. So I am responsible, I have to pay, but he, my lord, gets it, but I have to pay, but I get it from the insurance. Largely, there are many, at least 10 claims like this. My lord, the first part also, my lord, has this. Then, this is number one. সেদিন নোট করলাম কোথায়? Kindly give me 1 minute. I'll just পেছনে লিখছিলাম না, নোট করছিলাম। এটা কোথায় যেটা নোট করছিলাম? Millard, may I just hand up a chart once?
Mr. Ghosh, when does Mr. Shah come back?
Immediately after Puja vacation. He is in London now.
Immediately after Puja vacation?
No, not that. After this Lakshmi Puja vacation.
So, about what date? 4th, 5th? 21, 26th?
After 6th, what he has indicated to me.
So this is a longish matter, then I would not have the advantage of looking
Lordship,
into
what I'll do, I'll send the notes of argument to Lordship.
I'll give you till I'll give you till sometime. Otherwise, without the notes, this matter I can't.
Yes, that's it.
I'll miss out something or the other.
Lordship.
Because I'll have Mr. Chaudhary's notes before that.
Yes, Lordship. Mostly
I'll give you till say 6th he comes back. I'll give you till 9th. 2 days after that.
Yes, Lordship.
Yes, Mr. Chaudhary. Sorry.
Please see my chart so that I don't will not take more. Third party liability claims. I've given my learned friend the chart also. Claims awarded when respondent claim, but petitioner's counterclaims not awarded and directed to claim from insurance. These are the claim numbers and the pages of the award. Then number 2, despite rejecting overhead costs and profit in claim computation, whole claim allowed. claim B8, para 132. Then 80% of claim amount awarded with no justification. Question I ask myself is why 80%, why not 70, why not 60, why not 90? Then 4, claim awarded despite arbitral tribunal holding in para 122 that petitioner cannot be held liable for expenditure that the respondent claimant has to make to retrieve plant machinery and restart the work. So finding is contrary to the
You have
award.
given the pages of the findings also.
Yes, yes.
What
It's
about
all
the-
short findings.
No, the finding is in a different page than the claim award.
No, my lord, I'll just let's not take
If it's
paragraph.
not given, then put it. I'll just.
It's in one page, paragraph 132 of the award. My lord, kindly come to 132.
No, need not come. I mean, in your chart. I'm saying that in your chart.
Yes.
Suppose you say claim awarded despite 80 holding in. Oh, you have given.
Para 122.
Oh, yes. Right. Sorry.
So the claims are contrary.
Para have been referred. No, like in item 2, you have said despite rejecting overhead costs.
And profits in
So
claim
that has been
computation,
rejected
whole claim allowed.
in the claim while adjudicating, while awarding the claim itself. Very well.
Yes.
Get your
So
point.
my lord, then my lord, page 98 of the award.
No, need not show those. I'll check with you.
The most dangerous, my lord, is what I'm going to show your lordship. Paragraph 137. This is, my lord, dangerous. Declaratory award to all costs and expenses which will be incurred in respect of all ongoing and subsequent work to be undertaken as stated herein above.
Oh, here the shoe really pinches.
So, my lord, this is work not even done. That's why I say, my lord, 1,000 crores.
Additional cost towards compensation, hotel and rental accommodation. But these are being done by them.
Same contract is still going on. They still haven't
No,
finished.
this additional cost towards this compensation, hotel and rental accommodation has to be borne at the first instance by the contractor as per the contract.
Yes, my lord, no, this is, my lord, this is the, upon the incident happening. What had happened was,
yes.
we, my lord, said that we are going to bear all expenditure and
Yes.
we claimed it from them. When the award came, they stopped paying us. Now, my lord, I am continuing to pay.
No, but these are third party claims. That is what we are saying.
That's not the, my lord, one.
I mean, in the sense that people who ask for compensation, they have to be paid. So these are basically third party claims which you are meeting.
Yes.
Either you will be meeting or them.
Yes. Now, my lord.
So that liability is cast on you. Basically.
Liability is cast. This is not, my lord, the most dangerous variety. Here, my lord, if the finding is that they are not responsible,
yes,
then, my lord, I should have been given the right to, my lord, get this all from insurance. But
yes.
that's not the dangerous part. Dangerous part is, my lord, B.
157.
Balance quantities executed and to be executed in future by the claimant after 31st August 2022 for construction of shaft in Bowbazar area and restoration of tunnel as per actual quantities executed at site for the rates of items taken while calculating claim number 14, dam grouting work, etc. Now, what is happening is after 31st August 2022, all work which they are doing, there's already an award. So whatever they're doing, they're going to put it into this. And there are 3 more references pending. First reference is, my lord, after this, my lord, reference number 1 is a large reference with, my lord, many such incidents.
With other contractors?
No, with him.
So by different references?
My lord, passage of time, claims. There have been other incidents of inundation.
From the same transaction.
Same contract. So, my lord, this is Bowbazar incident, 31st August 19.
Other areas.
Other
Opposite was
areas, the one area. No, there have been other flooding also subsequently.
in other areas.
Other areas in the near vicinity.
Oh, those references are for those other
For
areas.
those prolongation claims as and when they arise. So in respect of the same contract, there are, my lord, 4 references now.
This will affect those.
Absolutely finished me there. I am surviving on the interim order. I put in the money and there is a virtual stay of the award. The learned judge, my lord, was at least, my lord, kind to, my lord, pass that award when we explained that we will be
Virtual stay means?
stay of the award, my lord. So, my lord,
I thought
so-
it is virtually.
No.
So there is a stay subject to your
there is a
payment and
stay.
your
So other references I'm surviving by saying award is stayed,
all right. Yes.
effectively stayed. So don't look at the award, do it de novo. So this is a finding which will not completely finish everything. To on the last day, my lord. No, this is on claims. I don't want to take more time. I'll put it in the note. Give them the note also. Now, my lord, on the last day, I had shown your lordship one letter on the 28th August, where we wrote number 1. There's a lot of brushes, a lot of water egress being shown. GC wrote lot of water egress shown. You find a suitable spot and change your brushes as fast as possible. And there are no brushes.
Yes.
Then I've also shown that on 30th, there were no brushes. And that one chart they've relied upon.
Yes.
And that document, which I'll cover in the note. This incident would not have happened if the brushes were there. This incident has happened because in the TBM, there is water which goes in, water smug grout, which tilts the balance. And that's the reason for the incident. So brushes were available, brushes had not been ripped off by proper handling. This incident would not have happened. The TBM is the perfect machine, which has been demonstrated when Dr. Endicott's person, under his supervision, the rest of the work was done. It's only for him and he can't avoid liability. This is public money and non-consideration of anything which we brought on record. These are my humble submissions.
So what is the latest position? The Section 34 code cannot modify. Can remand.
Can modify, I think.
Can modify up to within certain parameters.
Yes, that larger
If you
judgment.
can get hold of that judgment,
Yes, I'll
citation, just I took down the citation somewhere and lost it.
I'll be like, no, I have
just
it.
give the citation, either of you can give, because it's a common ground.
And
I'll have to consider that also.
Yes.
So that put in either of your
Note, I'll provide.
audio, both your notes. I mean the latest judgment on that.
Our prayer is, my lord, for a consideration of our evidence.
No, I understand that, but have you got that citation?
2025.
Oh, 1 second, Miss.
Online citation.
Yes, SCC online citation only. I'm 20
25 SCC online. SC
986.
986. Gayatri Balsama and Novasoft Technologies.
Thank you so much. Thank you so much. Thank you very much.
Our humble prayer is we had 5,000 pages that should be considered by somebody. That is the whole issue. That's the purpose of an arbitration.
Somebody is very ominous. The arbitral tribunal. Be specific.
Yes. A proper
Not
arbitral tribunal.
So hearing is concluded. Pushed up. On the learned counsel for the parties are requested to file their respective written notes of arguments in view of the extensive arguments advanced. Pushed up. On the prayer of learned counsel appearing for the respondent, the time for filing such written notes of arguments is granted till October 9, 2025. Please do it by that.
Yes,
Push up such written notes of argument shall be submitted in my email ID, which shall be circulated between the parties during the course of the day. At a kagos da likhe dicchi. I'm giving you right now, just take a note of that. My first name, first 4 letters, 4237. First phone number, email.
He knows.
Sabi 4237.
No, I've never sent an email to your lordship.
SEBI 423.
No, I'm just giving it.
No, he's saying that he knows.
No. We have never had any exchange. Even at the bar.
Even at the bar.
Email.
We have never. I have never appeared as your lordship's junior.
No.
I've only appeared against
me. Yes.
Against.
So I still carry that grudge. But that will
Deeply
not be
obliged.
reflected here.
No.
It is postponed for infinity.
Much
Thank you.
obliged.
So next
Much
matter.
obliged.
Thank you. Next matter call করুন যদি কেউ থাকেন তাহলে হিয়ারিংটা স্টার্ট করুন কল করুন
Item number 6 to item number 9.
6 to
Oh,
9.
Your Lordship, I beg to appear online, Your Lordship.
yes
Your
absolutely
Lordship, I'm appearing for the respondents. I'm being led by Mr. Shumabu Ghosh, Your Lordship. May this matter be fixed 1 week after vacation.
But in any which ways, my lord, I could not have completed it today, my lord. I've been led by my lord, an array of seniors. Mr. Joyanta Mitra is there, Mr. Tilak
yes
Bose is
they
there.
are.
So, my lord,
No, actually, Mr. Bose has been hovering around for many days.
Yes, it is.
So that's
Yes.
why also I made it a point to call it today.
But I believe your lordship is, my lord, taking up these matters till, my lord,
12 today.
12.
So no time today.
No time.
On the prayer of the respondent, the matter is adjourned for the day.
I'm grateful. My
For
lord,
the day has to be after vacation.
just
Yes.
immediately, whenever the matter is taken up next. We wish your lordship a very happy holiday.
Same to you. Sir. Thank you, sir.
Item number 10 with item number 11.
Not today.
Wait, please.
Yes. You're appearing. Oh, you're appearing.
I'm here, Malad, in item
Oh.
number 10.
Yes, you are for the
I'm for the petitioner, Malad.
right. You can start if you want. We have 10 minutes because today
Fine.
I'll be taking up original set matters up to 12. Last day of court, so after that appellate side.
I follow, Malad. It's
You
subject
can-
to Malad. Malad, I won't be able to conclude for sure. But if
But
Malad want.
you can
Yes.
formally start. You can formally start, please.
Okay.
গিট খুলতে পারছো না বড় ছুরি রাখবে একটা ছুরি অনেক কাজে লাগবে
Malad, it's a
আমি
voluminous
একটা
matter.
পুরোপুরি ইউজ করতে পারবো yes please I have the brief.
I'm obliged, Malad. Malad, I'll be referring to Malad had already heard us in part.
Oh yes that matter right
Yes, some part Malad had already here. Malad had already sort of got a sense of the matter in terms of a bird's eye view.
yes
I will just be, Malad, the endeavor in the next 10 minutes to my mind is going to just be to refresh what we have already put before this honorable court. And then subject to the availability of the bench post the vacations, Malad, then we'll be there.
right
So, Malad, if I can just point out to this honorable court that I'll be referring to, just for today's purpose, Malad, I'll be referring to the file where the majority, so Malad, there is a majority award and a minority award here.
yes
One of our grounds and the primary grounds to begin with is to say that actually the majority award is marred by fraud. And why we say, Malad, that the majority award is marred by fraud is because the presiding arbitrator, to our knowledge and on the basis of what we have put on record, was not in a physical or a mental state to give an award. Secondly, Malad, he has signed the award on dotted lines without any independent application of mine. That's going to be my first submission, Malad. And that is where I had taken this honorable court through the medical records which is already on record, Malad. And my endeavor was, and just to indicate to this honorable court that the learned arbitrator, the presiding arbitrator, was hospitalized just 2 days before the final delivery of the award. And he was, Malad, in hospital for at least a span of 2 months. In two different periods, just immediately before the pronouncing of the awards.
The 21st of April 2020 to 28th of May 2020.
Yes,
and then
so
14th of June to 20th of June.
I am obliged. 14th of June to 20th of July 2020.
July, right.
Yeah. So first period, Malad, was from 21st of April 2024 up until 28th of May 2020. Yes.
2020, yes.
I'm sorry, 2020. I'm sorry. 21st
yes.
of April 2020 Up
All in
until-
2020, 21st of April to 28th of May, and then
Correct.
14th of June to 20th of July.
Correct. And the award has been pronounced on 22nd of July.
20, yes, right. Yes, Mr. Chandra.
And the important aspect is, Manoj, that the submissions by the opposite side came only on 11th of June 2020. So in terms of chronology, Manoj, just about 5 dates are relevant. The date when the arbitral tribunal concludes the hearing is 18th of January 2020.
Right. Yes.
The petitioner, which is Malaj, I am the respondent there in the petitioner before this honorable court. I filed my written submissions on 28th of February 2020. The learned presiding arbitrator falls ill on 21st of April 2024.
Right.
And remains in the hospital until 28th of May 2020. Thereafter, Malaj, 11th.
So he was in just in the middle of the two hospitalizations when their submission came.
Yes, Malaj. Their submission came on 11th of June. He is in the hospital on 14th of June.
Yes, right.
And he remains in the hospital until 20th of July. And then one day immediately after that, the award comes.
Yes.
And just to sort of tell this honorable court, the time span over which the arbitral tribunal took sort of hearings is close to a period of about 10 years.
10?
10 years, Malaj. So the matter started.
Oh.
Yes. So the matter, Malaj, started in 2010. And it got concluded finally in 2020.
Right.
So what I'm trying to sort of emphasize before this honorable court is that the number of hearings, the number of cross-examination and the voluminous record was so much that it was impossible for anyone to have gone through that record within a period of a day and then to pronounce, Malaj. And if my lords remember, I will take my lords to those relevant portions of the award later. But if my lords remember, the award is pronounced in the first person of the presiding. Yes, Malaj. Yes. First person of the presiding arbitrator. It is not even as if the second arbitrator had made the award and the presiding arbitrator concurs with him.
True.
So, Malaj, that is the first. I'm just recapping everything, Malaj, and I'll take my lords just to refresh everything later. But the first submission is this, and I say categorical statements I have made in my petition as to how this is fraud, Malaj. No consultation. One of the underlying threads of an arbitration is consultation, Malaj, or agreement.
Right.
There couldn't have been a scenario for even the presiding arbitrator to agree with the second arbitrator. And the nature of his ailments was such, Malaj, with altered mentation, Parkinson's, cardiac arrest. He was on ventilator. He was not oriented in space and time.
Yes.
It was not possible, therefore, for him to have pronounced a 120-page award within a span of a day, or to have even understood. I could have, Maharaj, it could very well be the case of anybody that it is actually prepared by the second arbitrator, read and concurred by the first, which is fair enough, which is a fair award. But that is not the case, Maharaj. So the first point, therefore, I'm trying to put before this honorable court is that the learned presiding arbitrator, therefore, signed on dotted lines and not understanding what he was signing on. And therefore, this is a fraudulent award per se. That's my first leg of submission under section 34.
Right.
The second leg, Malaj, that I had propounded the other day is violation of section 31, subclause 3 of the Arbitration Act, which basically says that any award which is by the majority or any award which is by 3 members must mention the reason for the non-signing by the third member.
Yes.
It must say, and it happens also, Manoj, on the judicial side, that if there are more than, if it's a full bench or more than 3 judges, Manoj, if somebody doesn't concur, usually the majority judgment contains a caveat.
Yes.
That learned brother so-and-so has not agreed with us, is pronouncing a separate award or a separate judgment per se. But that has not happened, Manoj, in this matter. In the entire award, there is no reference to the third arbitrator. There is no reference that the third arbitrator is going to pronounce a separate award. To the contrary, the minorities award, which is the third arbitrator's award, he specifically states in his award that I was never informed. It was only communicated to me on the date of the award that an award has been pronounced.
Yes.
Nothing beyond that. So that actually bolsters my argument, that supports my argument, Malaj, that there was no consultation, even with the third arbitrator. That's my second leg of submission, Malaj, on 31.3.
So we'll
Hello.
continue after the vacation, Mr.
No difficulty, Malaj.
Chindra.
I'm grateful, Malaj.
Hard in part, full stop. However, due to paucity of time, the hearing cannot be concluded today. Full stop. Accordingly, let the matter stand adjourned till after the upcoming annual vacation of this court. Annual vacation of this court. Yes. Thank you. We'll take up appellate side matters after this. After 12, sorry. Thank you.
I'm obliged.
Item number 1.
Mention.
My lord,
Today.
no, I am not. Before taking my lord, may I permitted? 59 and 62, both are expeditious disposal. Can it be taken?
No, after, whenever, before the regular.
159, my lord. Interim order will expire in September 30, my lord.
Mention before the vacation, mention, no problem. Yes. Follow the list.
Execution will proceed with.
Item number 1, I am appearing for the petitioner, my lord, unfortunate petitioner. Last occasion I am unable to file as because the your lordship was the.
What was the nature of the contempt?
Yes, my lord.
Nature of the contempt.
Nature of the contempt?
Contempt against the. First, I am telling, submitting before your lordship the contempt raised now more than 100 years. Your lordship.
Petitioner.
Petitioner. And against the.
What's the nature of the contempt? This is that freedom fighter?
Yes, freedom fighter. Freedom fighter. There are Palki for the Mr. Alapan Bandhavadhyay and Hare Krishna Trivedi and Manoj Pant and Nandini Chakraborty.
What is the explanation? Who is to explain?
File the opposition, file the affidavit. They are not contemnor. So I should file the reply, but my client unable to move, and therefore, your lordship, I am praying before your lordship, my on behalf of my client, the daughter of the
contemnors themselves have filed the affidavits.
Yes.
Yes.
They are.
There is a question of reply. This is between the court and the contempt.
Yes, I know. I know the status of the contempt. Your lordship knows it very well.
I know you know.
You know.
I know that you know. Yes.
But is in this case required?
Required.
Required.
Then we'll have to dismiss with personal service unnecessarily prolonging contempt. Let us hear them first. Yes. Please. Let us hear them. Yes. We understand. Let us hear them first. Yes.
On that day, your lordship.
Let us hear them first, please.
Yes, madam.
Please take your seat. Please take your seat. Please take your seat. Yes. Yes.
We have the director of freedom fight. We have passed an order. So
where is it stuck up, Mr. Bhattacharya? Where is the pension stuck up? At what stage? Before whom? Which authority? No, just tell us. Oh, this is going on for too long, Mr. Bhattacharya. Now he has to wait for Bangladesh.
Contradictory report has been filed by the state.
What contradictory reports, Mr. Dutt?
There is contradictory report. Two reports, the tenure.
Dates of imprisonment are different.
Tenure of imprisonment does not match. Given by the petitioner. Yes. The second report is based on the petitioner's
unverified document, but by petitioner. So your report says, so he was imprisoned less than 6 months. 6 months is the requirement. But when was the order passed?
Order was passed on 6th of February.
Let us. What was the date of the order, Mr. Dutt?
6th of February 2020.
2020?
Yes, my lord, sir.
Then for 5 years, you were waiting for his demise. He's located in present-day Bangladesh. So who is to take information from there? You have to take information then from Bangladesh. You have your pension scheme, Mr. Bhattacharya. You have to ensure that this is given to proper entitled persons. 100-year-old man, he's counting his days.
Record department received on examination of all documents, irrelevant documents found that the primary evidence is doubtful in nature and it is not verified.
The direction was to grant or after verification to grant?
Look, we have received another letter in the meantime. Possibly, the central government is taking up the matter with the Bangladesh government. It appears so.
Yes, they're taking steps. We'll keep this on record. What opposition? What will you do? State in your opposition. What do you want to deal with? The question is whether they are taking steps pursuant to the order of this court. This court directed them to consider your application and after scrutiny to
last 5 years repeatedly send a letter to the
True.
and every month every month SDO
We'll keep the contempt alive. We'll keep the contempt alive.
Gone to the party Satish Chandra and then submit the report.
We'll keep the contempt alive, but because contempt, I'll keep the contempt alive, but dismiss with personal appearance for the time being. But we'll ask for a follow-up report on this as to what has been done from the central. But they have rejected, Mr. Dr. So, what is the meaning of this, Mr. Bhattacharya? Please explain paragraph 8 of the one you handed over. It is regretted to inform that could not be considered fit, but the ministry has requested Minister of MEA checked from Bangladesh government, which is corroborated by Mr. Datta's what he handed over today. So we'll wait for some time for you to get that.
My lord, the 10 September letter, which my lord, the learned advocate.
Yes, 10 September.
This was after we filed affidavits. My lord, this has come now.
Oh.
10th of September. Lord, our affidavits are of an earlier date. My lord, where we have annexed the 21st August letter, which your lordship's reading. My lord, paragraph 8. My lord, regret. After that, my lord, because it's only the central government which can correspond, my lord, with my lord, the Bangladesh government on this issue.
So how far we can proceed in contempt, that is also in question. I'll keep the matter alive.
Yes.
Act order record Conan. The affidavits filed today by the alleged contempt.
One thing I submit.
We'll give you.
In the meantime, anything happen about the informer of the contempt petition, the daughter will be continued. Only child.
The?
Only child. Daughter.
Daughter will be entitled to apply,
yes,
proving her heirship.
As per law.
That is as per law. That is not a subject matter of contempt. That is an independent right, actually. You have to establish your right, heirship, and whether daughter is. That conundrum is also there. Married daughter and all.
One thing I shall submit, my lord. If you.
Yes, I remember. I passed a contrary order, but probably I don't know the fate of that.
Lordship give me opportunity to file any affidavit, you then affirm by the daughter.
Daughter can always, if she has direct knowledge, she can always affirm. But where is the scope of affidavit of this on this? What do you want to? You cannot have any knowledge of what steps they have been taking.
There is some documents.
Affidavits filed by the alleged containers today be kept on record. Full stop. Learned counsel appearing for you are for.
Director, my lord, freedom fighter department. Because my lord, no copy of any notice of the sir.
No, you are appearing for which of the contemners?
Has not been served.
Learned counsel having instruction to appear.
Party no.
For the central government, I am putting it.
That is the false.
I'm putting it vaguely. Central government. For the central government files.
This is the first time central government appear before your lordships.
A copy of a communication dated September 10, 2025, issued by the authored by the director within bracket EZ, comma Ministry of Home Affairs, comma Freedom Fighters Division to the Joint Secretary, comma Ministry of External Affairs, which indicates that in order to implement the order of this court dated February 6, 2020, passed in WP number 4725 within bracket W of 2011, comma, seeking information, seeking the matter to be taken up with the Bangladesh government, where apparently the records pertaining to the imprisonment of the freedom fighter stroke petitioner are lying, comma, and to follow up the issue. Full stop. Such copy of the letter dated September 10, 2025 is kept on record. Full stop. Learned senior counsel appearing for the alleged contemners points out that the said letter was written only after the affidavits were filed in the matter. Full stop. Next para. Another letter is handed over by learned senior counsel, the learned advocate general appearing for the alleged contemners. Some of the alleged contemners. You are appearing for the others.
Yes, my lord. We are, my lord,
Of course.
First, some of the alleged contemners also hands over a copy of a letter dated August 21, 2025, written to the petitioner by the director within bracket EZ, comma, Ministry of Home Affairs, comma, also pursuant to the order of this court, comma, seeking certain informations and indicating that there are two contradictory inquiry reports furnished by the state government. Full stop. Next para, it transpires therefrom that one of the reports, comma, putting the period of imprisonment between August 27 and August 27, 1942 and March 13, 1943 was based on an unverified document produced by the petitioner, whereas a report dated March 4, 2021 puts such period between March 27, 1943 and September 11, 1943, which is less than 6 months, comma, disentitling the petitioner from freedom fighters pension. Full stop. Next para. It appears, it transpires from the parent order passed by this court, comma, which was the genesis of the present contempt application, comma, that directions were passed on the respondent authorities to disburse, to consider the application of the petitioner for disbursal of freedom fighter pension and, comma, if so entitled, comma, to disburse the same to the petitioner. Full stop. Next para. Although it is argued by the alleged contemners that the contempt application has spent its force by dint of the authorities having considered the application of the petitioner and rejected the claim, since the necessary documents to verify his antecedents for entitlement to the pension were not found or produced, comma, it transpires that since further efforts are being undertaken by the Ministry of External Affairs to verify authenticity of documents with the Bangladesh government, comma, where the records regarding the imprisonment of the petitioner are supposed to be lying, comma, let the contempt application be listed on November 7, 2025 for passing further orders. Full stop. Next para. The petitioner is granted liberty to file rejoinder, comma, if any, to the affidavits filed today by the alleged contemners. Full stop. Next para. The personal appearance of the alleged contemners is dispensed with for the present until further orders.
And my lord, the rejoinder should be affirmed by the daughter.
Why should I say that? Yes. Acha. Copies of the affidavits filed today be circulated among the parties. Give a contempt. Right now.
This is the first time he appeared. There I shall supply.
Yes, Mr. Mukherjee was saying.
I shall serve. You do not know the facts of the case.
My lord, the alleged contemners have appeared today, my lord. Your lordships may record it.
Oh, yes. Prothom line rekhe do. The alleged contemners are appearing before this court virtually.
Virtually.
Yes, they are there.
Your lordships gave that liberty.
Virtually, as per previous direction. Pustak. তারপর লাস্টে যেটা বললাম dispense with for the present until further orders.
And my lord, one other thing.
Yes, Mr.
My lord, I might be wrong, my lord. I heard your lordship say, my lord, that the 21st August 2025,
yes,
my lord, document, my lord, that is in the affidavit. My lord, it's only, my lord, the September, my lord, 10th September, which has come after
21st
that.
August, this someone handed over, not you.
No, this is part of the affidavit.
It's part of our affidavit.
একটা জায়গা দেখবে ডেট রয়েছে থ্যাংক ইউ মিস্টার একটা জায়গাতে ডেটটা দিয়ে সার্চ করো যে অগস্ট 21 2025 অগস্ট 21 2025 দেখো আগের পাতায় অগস্ট 20 হ্যাঁ আছে তো ব্র্যাকেটে which is also a part of the affidavits filed today recorded there.
But it's also an annexure to our affidavit, you know. It's addressed to us, we've annexed it.
I'm happy that my learned friend appeared on behalf of the Union of India first today. I'm happy. I shall
appreciate your happiness.
In accordance with your lordship's
My lord,
order.
may I just say one thing? My lord, this is really unfortunate, what has happened. And my lord, I was sharing that view, my lord, with the learned advocate general, that my lord, this kind of a person can't be tossed, my lord, left from pillar to post.
There are other instances also, Mr. Mukherjee. I have been regularly getting these matters in the residuary side. regularly. There are many such persons. Some are not genuine, yes. You can get a feel from seeing their applications, but some are really genuine. 100-year-old person, what will he gain? Just the recognition, Mr. Mukherjee. Just the recognition, nothing else. And his application is rejected, and now Bangladesh.
My lord, I have requested, my lord, persons I know, my lord, who are, my lord, in the state government as well as central government, who are IAS officers, to see, my lord, if they could speak to, my lord, our envoy, my lord, who
Thank you
might be a, my lord, batchmate or so, my lord, to, my lord, try and expedite this.
Thank you so much, Mr.
My lord,
Mukherjee.
I
I
have
mean, it's
indicated that.
it's more than appreciated. I mean,
Sir, that's because this is, my lord, what
see
will
the
we,
plight of this person.
and my lord, where do we argue? What do we argue, my lord?
What do we argue exactly? The conscience
My lord,
speaks.
individually, they may not be, my lord, liable, my lord, what they have done.
No,
But, my lord, this
true.
is not, my lord, how we, my lord.
This
should
is
treat
not
our
about the
freedom fight.
people,
Correct,
the alleged
correct.
contemners. This is about this person. I mean,
I have said
we have to have some teeth to our orders to see that these persons. We are helpless without the officials. We cannot do. The court cannot do anything by itself. Court cannot go to the field and implement its orders. Definitely not. That's the legal fiction we are standing on. So that's why the contempt jurisdiction we use sparingly, Mr.
But I
Mukherjee.
was
No.
actually hoping your lordship had passed an order, pay the pension. That would
No.
have solved the problem.
No, but in contempt, because they have rejected.
My lord, before, my lord, the first order. I was saying, my lord, why not that order? Rather than, my lord, leave it.
No,
my
that
lord,
would get set aside in a second.
may not have, my lord, may not have. I'll tell you, your lordship, my lord, the state government, my lord, my learned friend will bear me out, my lord, are conducting camps, and my lord, there are, my lord, a conscious effort now, my lord, on the part of the state government to ensure, my lord, that pensioners, my lord, get payment. But last gathering was 98 persons. my lord.
Difficult.
We put it on.
That's excellent, Mr. Mukherjee. But the similar thing happened in the premature release cases of the convicts.
Yes.
Several opportunities reconsidered, one police report, the gravity of the offense only, not the current things, nothing, and again repeated. So lastly, we had to direct that release him at the risk of being set aside. Setting aside is not a problem for the judge, but even then, I mean, if it's set aside, the relief you want to give is not given. That's why we try to couch it. So now, if I get residuary, I won't probably. Then I would have done that.
Well, then your lordship might get the appellate.
Thank you.
I'm grateful, Brush.
Happy vacation to all of you. Thank you so much. To all whoever is present.
Item number 2.
Yes. Yes.
Item number 2. I am for the opposite party in this
Opposite
case, your lordship.
Petitioner, yes.
Lordship, I am for
before-
wife. The case is that this case was last heard on 5th of August, your lordship.
So what?
On that day, I have appeared for first time. And on that day, my lord justice has directed the petitioner's counsel
My lord.
to serve as a copy within
Before you-
1 week. But till date, every day we used to follow this case, and today this matter is appearing as item number 2, your lordship. Still now we are not having the brief. They have not served us.
My lord, before I start on the merits, my lord,
Are you enjoying an interim order?
No, your lordship.
There was
nothing
an-
is there.
my lord,
Why have you not served a copy?
My lord, I have been instructed that that
Withdraw.
application, that application has been served on the client.
No,
So
no, no,
today,
no, no.
today,
File your affidavit of service.
Absolutely.
my lord,
File your affidavit of service.
my lord,
That
I undertake to serve them by 3 p.m. today. But I ensure and I undertake it to serve them by 3 p.m. today. I won't be pressing on the merits of the matter. Only an order has been passed by the learned trial court that the matter be sent to the district court at Murshidabad and present the plaint. So there has been an extension which was granted till 23rd of September.
No, you have not served a copy. No, order will be passed in your favor. Sorry.
Deep
Go back to the regular bench.
Lordship.
Learned counsel for the opposite party at the outset points out to the order of the coordinate bench dated August 5, 2025, whereby the learned single judge directed the petitioner to serve copy of the revisional application on the learned advocate having instruction to appear for the opposite party. Full stop. However, it is submitted that no copy has been served on the opposite party and or her learned advocate till date. Full stop. Next para, learned counsel for the petitioner submits on instruction that a copy of the revisional application has been served directly on the opposite party, but on query of court, fails to file any affidavit of service or show any proof of such service whatsoever. Full stop. Accordingly, let the matter stand adjourned till after the stand adjourned for the day and be relegated to the regular bench having jurisdiction after the upcoming annual vacation. Thank you. Next.
Deeply obliged.
Thank you.
Item number 3.
Yes. This is the second occasion when none appears for the parties at the time of call. Full stop. Let the matter stand adjourned for the day and be relegated to the regular bench having determination. Next.
Item number 4.
None appears for the parties at the time of call. Adjourned for the day.
Item number 5.
My lord, learned counsel.
On the last occasion, I granted you time. No further time. Move the matter. Where is the file? Yes.
My lord, my senior is suffering from adverse health issues. So
From?
Adverse health issues. He was supposed.
What adverse health issues?
He has been
started after the matter was assigned to this bench.
No, sir.
Then?
He's been suffering since Monday night.
Very well. Learned counsel for the petitioner seeks an adjournment on the ground of illness of counsel for the petitioner. Stop. Accordingly, let the matter stand adjourned for the day. You are appearing for the other side?
No, my
Next matter. No.
Next matter.
Not taking a chance by standing behind.
Item number 6.
But I am for the opposition.
Already filed the review. Yes.
But in this matter, I beg to appear on behalf of the petitioner, my lord. My lord, today I am
helpless.
Well, this is nothing. My lord,
But you will also kindly see the order only.
No, what is your
then my lord, I am submitting.
bench phobia? Bench phobia. Bench phobia.
No, my lord. No, my
Some
lord.
other illness.
No, my lord. The matter has become, my lord, why it has become infructuous, I will tell my, I will.
It has been infructuous. They will hold that.
Kindly, then kindly hear me for a moment, my lord. There was a school model of this honorable court. My lord, I came before this honorable court challenging the occupational charges. In respect of a degree, I suffered for eviction. My lord, the occupational charges was high 100 times. I got a sole order of this honorable court, deposit 70,000, one-time payment. I sent my communication letter and requesting them to come before this to come before the lawyer's chamber of my learned senior friend's lawyer, the Bardwan court, to collect the money as it was directed. All the envelopes, 6 envelopes, 5 or 6 envelopes, all were refused. Nobody came. Then I
tendered the money in the
entered the money to come in the Bardwan court premises to collect the money as per the solemn direction of the honorable court. The letters were refused.
The direction is given by the appellate court or by the.
No, my lord, this honorable court. This honorable
in
court.
appeal or something. Occupation charges. What was the occasion for granting occupation?
My lord, the execution
charge is that trial court has given 7,000 rupees per month.
Trial court means executing court.
Executing court. He has filed
Why
an
they asked for
application.
stay before the executing court itself?
Yes. Then court has decided that you one time
100 rupees, it was enhanced to 7,000.
So after that, what happened? These envelopes?
Envelopes all came.
That story is over then.
The lawyer also refused. Then my.
What did you do after that? Proceed after that.
Then my lord, ultimately, I moved before the learned court below, and thereafter they took no steps, and the miss case for execution case and also the application miss case for police help were dismissed for default.
So let me dismiss this as infractious. Dispose of this. Miss case has been dismissed. Your execution case has been dismissed.
My instruction, I have
execution has dismissed. They have filed an application for
restoration.
But then, my lord, kindly keep it after vacation, my lord.
The counsel for the petitioner submits that the execution case levied by the opposite parties decree holders, from which the present matter arises, has itself been dismissed for default. Next para, learned counsel for the opposite parties submits that a restoration application has been filed in the executing court. Next para, accordingly, to await the outcome of the same of the restoration application, let the matter stand adjourned and be listed before the regular bench having determination after the upcoming annual vacation. Next. Thank you.
Item number 7.
Give your name, whoever is appearing with you, both of you. If anybody else is there. Yes. Yes, Mr. Pachal, what is the matter? Caveator has been served.
Yes, he has been
served
long before.
So, yes, fine.
Was.
So you move the matter then. If they choose not to appear, what can?
Lord, matter as out of suit for partition, Lord.
Right.
Lord, the petitioner was the defendant. Lord, in order to, Lord, it's a mud house. In order to.
Sir Pachal, can you please take the microphone a bit closer? One of them.
Sorry, ma'am.
Yes. No, no.
Lord, you'll kindly take trouble to look to the order dated 22nd February 2024. That was the order. It has been stated that you want during the pendency of the suit, my lord, I wanted to make the room habitable because in order to reside over there, I am the only, this is the only room where I am residing, Lord. That has been not the order of status quo was passed. Lord, only prayer is not regarding had to the fact that I don't want to get any equity out of it, not only in order to make the same habitable, not it was almost complete. Only the roof was to be completed. Not by that time, not the order was passed. Not the challenging that. Not I move this application. Not this next order. You also will find 2nd March. The necessary order was passed for 22nd February. As
So I'll give you liberty to file an order 39 rule 4 claiming your hardship and the present revisional application has been preferred by the defendant in a partition suit against an order, but this revision is not maintainable. This is status quo order.
Status quo, so this followed by the subsequent order.
Status quo against an order whereby status quo was granted, directing both parties to maintain status quo. Status quo was granted in respect of both parties.
Nature, character, and position.
Regarding the nature, character, and position of the suit property. Who's up next para? The nature of grievance of the petitioner, comma, as ventilated before this court, comma, is that the petitioner had almost completed a construction of his dwelling house on the property, and since only the finishing touches were left when the status quo order was passed, comma, the petitioner is suffering grave hardship. For sub next para, the impugned order of status quo is in the nature of an order under Order 39, Rules 1 and 2 of the Code of Civil Procedure, and as such, comma, is appellable. Full stop. Thus, comma, the present application under Article 227 of the Constitution of India is not entertained. Full stop. Accordingly, CO number 1322 of 2024 is dismissed as not maintainable, granting, comma, however, comma, liberty to the petitioner to take out an appropriate application under Order 39, Rule 4 of the Code of Civil Procedure, pleading his hardship and stroke or file a proper challenge by way of an appeal against the impugned order, comma, subject, comma, of course, comma, to limitation, no orders to cost. প্রথমেই লিখে নাও receipt of notice of service filed to be kept on. Thank you. Receipt of notice for dispatch service, none appears for the caveat or opposite party. Thank you. Next.
Item number 8.
None appears for the parties. Adjourn for the day.
Item number 9.
My application.
Yes, Mr. There is any caveat or direction for service? No.
First time appearing. The caveat, the preemptor is a petitioner.
Yes.
Order was passed. At page 33. Thereafter, assailed by the opposite parties.
Preemption was granted by the first court, reversed by the appellate court.
No, it came up before this honorable court. An order was passed for dismissal of the revisional application for default. The other side came up before this one.
Other side challenged the preemption order.
Yes. No, not preemption order was challenged before the appellate authority, appellate court.
Appellate court affirmed.
Yes.
Against that
revision was filed.
Right.
Dismissed for default.
Right.
Twice. Thereafter, during
the restored again dismissal.
Yes. Then in between, execution proceeding was initiated by my client before the authorities, before the executing court.
Yes.
Now that execution proceeding got dismissed for default during the pendency of this proceeding before the honorable court, and thereafter restoration application was filed.
Right.
The restoration application was dismissed, and that is the order impugned before this honorable court. Since it was filed after a year or so, because we had taken the plea.
What is this order 2106 and all?
This is probably a reference with regard to the restoration part. I also was kindly takes the restoration application is page 66 of your lordship's brief.
1 second, just. He held that there was no sufficient cause.
Yes. The cause, my lord,
What was the delay in filing it?
delay, my lord, the dismiss for default was made on 8th of March 2016, and we had filed this restoration application on 10th of November 2017. We had taken this plea in our application that during this interregnum, the revisional application was pending before this honorable court.
I'm admitting the revision, but there is no scope of grant.
No. There is no scope of indeed.
The present challenge has been preferred against an order whereby the execution case filed by the petitioner in respect of a preemption order passed in favor of the petitioner by the first forum and affirmed by the appellate authority, comma, consequent to dismissal of a connected application under Section 5 of the Limitation Act. Full stop. Next para. Prima facie, it transpires that while passing the impugned order, comma, the learned trial judge merely quoted the propositions laid down in several citations, comma, without adverting to the merits of the explanation given by the petitioner in the condonation application. Full stop. Next para. The present revisional application shall be heard on the above question. Accordingly, the petitioner shall serve a copy of CO number 1327 of 2024 on the opposite party, indicating that the matter shall be listed before the appropriate bench, before the regular bench having determination, comma, subject to being mentioned by the parties, comma, and the petitioner shall file an affidavit of service on the next on the returnable date.
Well, before your lordship part with the file, my lord, I was mistaken, my lord. It is not a condonation application. There was no condonation application filed. It was a restoration application, my lord, saying that my date of knowledge was in respect of the dismissal of the suit of the execution proceeding.
যেখানে condonation বলেছে কোন registration দেখেন করে দেবেন নিজের মতো আমি করে নেব very
so very great.
There was no application under section.
No.
Item number 10.
None appears for the parties at the time of call. Not today. Adjourn for the day.
Item number 11.
Tanmoy Mukherjee appearing for the ballot petitioner.
Move the matter. What is the matter? No caveat?
No caveat.
Take your chance. Yes. What is the matter?
Ballot opposite party number 1, ballot file a preemption application, ballot
preemption granted by both courts.
No, preemption granted, ballot to the opposite party number 1, page 35 is the order.
No, rejected by the first court.
First court allowed the opposite party 1. Well, thereafter we preferred an
appeal. That was dismissed.
That was 105 days delay. We took no steps. That's why it has been delayed.
Section 5 has been rejected by the impugned order.
Yes. 8th of February 2024. There's a 105 days delay.
This was also rejected for default.
Yes.
So you are a habitual defaulter.
No, my lord.
Your section 5 was dismissed for default.
Yes.
So what is the wrong in the order?
My lord, only no.
Come back after the vacation. On the prayer of the petitioner, the matter is adjourned for the day. Next. Go before the regular bench.
Yeah. Item number 12.
Is the petitioner here.
Right. No caveat.
No caveat.
Yes.
But the preemptor
lost in both courts.
Yes,
lost in both courts.
No. First court lost.
Allowed.
Allowed. No, not allowed. The preemptor.
First court must have allowed. Otherwise, how could there be reversal?
Not reversal. The fact is that the petitioner approached the court for the delay because the application for preemption was rejected. Not the application, but the delay of the filing of the Section 8 preemption application.
Preemption application was filed late.
Then.
So you filed a Section 5 for that?
No, I filed the application relying on the judgment of the Honorable Supreme Court in because of that Corona period. And that was rejected by the trial court.
Your Section 5 application was rejected?
Yes.
Section 5.
No, section 5 not. The only normal application. Page. Page 49.
What is the prayer of the application? Page 40?
49. For
49, there is no 49. It's a certified copy. It's not paginated. Anyway, application for what is this sort of application? Application for conciliation of Supreme Court of order, order of Supreme Court. You have to make a prayer in the application. Oh, it was filed. You wanted the corona period to be considered.
Yes.
Those orders.
Yes.
So the limitation, the preemption application was filed late.
Late.
When was it filed?
It was filed on 28/9. But
which year?
2021.
Achha, that was within that Supreme Court period.
Yes.
Right.
And the property was sold on 25th March 2021. And we are paying for that delay, 6 months delay. From 25.
Preemption application, there is no scope for.
Yes, but at that time
But only the Supreme Court judgment may help you. You know, Section 5 is not maintainable.
No.
Let's just check up. But the court has found, on considering verbal submission of learned, on considering verbal submission of learned advocate for the petition, it could be stated that the purpose of filing the instant petition is regarding limitation period for filing preemption case. But the same could only be considered after trial at the time, as the right of preemption of the petitioner includes. So it will be considered at the time of trial. I'll not interfere, but I'll make it clear that this question, whether this preemption application was filed within time, has to be considered in the context of the Supreme Court judgment. The present challenge has been preferred by the preemptor in a proceeding under Section 8 of the West Bengal Land Reforms Act 1955. Full stop. Next para. Learned counsel for the petitioner submits that the preemption application was filed during the COVID-19 pandemic period and, as such, was covered by the several orders passed by the Honorable Supreme Court inter alia in the matters of MA 21 of 2022, MA 665 of 2021, suo motu writ petition within bracket C bracket closed 3 of 2020, etc. The preemption application was within the limitation period. Full stop. Next para. The learned trial judge, while considering the same, rejected the application on the ground that there is no provision in the West Bengal Land Reforms Act regarding condonation of delay in limitation period in filing a preemption case. Full stop. Next para. The learned trial judge further observed that the question as to whether the preemption application was time-barred can only be considered after trial, as the right of preemption of the petitioner includes the question as to the maintainability of the petition, which can be decided at the final adjudication of the case. For the next para, this court does not find any illegality or jurisdictional error with the impugned order. For the next para, it is well settled that a preemption application is in the nature of an original proceeding and, as such, Section 5 of the Limitation Act is not applicable thereto. Full stop. Next para. However, the petitioner stroke preemptor has definitely raised a valid question as to whether the preemption was filed within time, keeping in view the extensions of time for filing all applications granted by the Honorable Supreme Court from time to time in respect of the pandemic period. Full stop. Next para. As rightly observed by the learned trial judge, comma, the said question can only be considered at the time of final adjudication of the preemption application. Full stop. Accordingly, no interference is called for. Full stop. CO 1344 of 2024
2024, yes,
or 2024 is disposed of without interfering with the impugned order, but keeping it open for the parties to argue on the question as to whether the preemption application was filed in time, taking into account the pandemic extensions granted by several orders of the Honorable Supreme Court at the time of trial. No orders to cost urgent certificate. Thank you.
Item number 13.
And I'm for the Malad petition.
Petitioner, please.
Opposite party number
Opposite party number 2.
Opposite party, Malad. Petitioner, Malad, for enhancement of maintenance, Malad.
Alimony.
Malad, the petitioner is the victim of dispute between her parents. Her parents, Malad, filed one after another application or suit, and Malad, she is Malad staying with her mother. And Malad, her mother initially filed an application under section 125. And learned magistrate was granted 8,000 per month towards the petitioner. And Malad, now the petitioner attained the age of majority. Therefore, her maintenance under section 125 stopped. And Malad, he filed an application under the under section 20 of the Wards and Guardianship Act. And learned ADJ in this case, her case awarded only 2,000. Only 2,000. Where
You are a student.
You are a student. He was then the student of BSc. Now she is the student of master degree. And only 2,000. When the learned magistrate awarded 8,000.
What do you want? What was your prayer? What amount did you want?
She is want to 25,000 per month, as because
What's the income of your father?
Her father own affidavit that is page 30, 81,000 something in the year May 2023, page 30. My lord, kindly see the.
There is no page 30 here.
Right answer.
There is no page 30 here.
Huh?
There is no page 30.
My lord,
the last page is 27.
My lord,
28.
My lord,
Anyway, I find an affidavit of asset.
Affidavit of asset of the my lord, opposite party, father. Running page, my lord, 4. Affidavit of asset, page 4.
Yes, which item?
My lord, item number 3. Monthly income, my lord. Gross income, 81,838 as on May.
Even the net pay is almost 34,000, more than 34,000. 8,000 he is giving to his wife.
That is my lord net. And my lord.
Even proceeding on the basis of net, I mean.
No, my lord, this is not.
But deductions have been indicated here.
No, my lord.
Yes, what do you say?
My lord,
2,000?
My lord, another thing, my lord. My learned friend, my lord, on last occasion, my lord, raised one, my lord, question that, my lord,
let me submit my case, sir.
The dispute between the, my lord,
let me submit my case.
My lord, already went to the mediation. In mediation, the dispute between the husband and wife has been settled. But, my lord, this is the final order of the mediation. Your lordship will not find a single sentence about.
My lord, may I submit, my lord?
The petitioner
chance
about the, my lord, petitioner involvement in the mediation, or, my lord, anything about the, my lord, her case. That is, my lord, only, my lord, the mat suit number.
No, the amount directed to pay was 12 lakh in the joint saving account of wife and daughter.
My lord, only, my lord, both.
It's a joint saving account.
My lord, both, my lord, wife and my lord, daughter staying in a same under the same roof. And my lord, there is only one account, and both account is joint account.
Joint account?
My lord, joint account, my lord, does not mean, my lord, it is not at all clear that, my lord, this amount is for joint person.
Then it is between your mother and your.
Lordship, kindly see.
So your father cannot suffer for. He has paid 12 lakh in the joint account. Now it's between your mother and you. So you sort it out with your mother. If you have a cause of action, you have a cause of action. If you have a cause of action, you have a cause of action against your mother now. Because 12 lakh has been put into your joint account, your and your mother's joint account.
But my lord,
So why should he pay further?
in my lord joint account, my lord, the amount my lord mediator my lord decided that is in connection with the match suit and my lord the
Even then, the money, the color of the money is the same. In a match suit or a miscellaneous case, the
my
color
lord,
of the money is same.
I am not my lord at the my lord mediation center, or my lord I have not my lord.
If you are not happy with that mediation, you say you have an independent right of maintenance.
No, my lord. Yes, my lord. Just because my
Then you have to forego your rights in that 12 lakh.
Yes.
You are ready to forego your rights.
Yes.
Should I record that?
Yes, my lord. Yes, because my lord, I am not.
Yes. What do you say? She's
invited
understood.
me to participate.
Acha, you had attained majority when this was entered into.
My lord. My lord.
Yes, she is not a party to this mediation.
My lord,
Why should it be binding on her?
My lord, actually the thing is that at the time of mediation, as per my instruction, daughter was also there. Both
Your instruction won't do. That is not
but
recorded.
only there is no agreement. My learned friend is taking that advantage, my lord. Nothing more than that. The amount is disbursed between in the joint account, my lord, of the daughter and mother, just because there is an amicable settlement. Only the problem is that there is no agreement. Taking that advantage, petitioner is before this honorable court, my lord.
She might have been set up by her mother.
My lord. And my lord, kindly direct them to serve me a copy and come back, my lord.
My lord, I have already served.
No, my lord. Kindly ask him to produce the affidavit of service.
Produce the affidavit
making
of service.
False submission.
Produce the affidavit.
In presence of my lord learned, honorable justice, my lord.
Produce an affidavit of service by justice, whatever.
My lord, in presence of my lord.
Take out another photocopy. She has been granted 2,000. You pay for the Xerox copies.
Then my lord, why my learned?
Learned counsel for the opposite party submits that no copy of the revision application has been served on him, which is denied by learned counsel for the petitioner. Be that as it may, the learned counsel for the petitioner is requested to serve another copy of the revision application on the opposite party. Next para, learned counsel for the petitioner hands over a copy. Learned counsel for the opposite party hands over a copy of a final report of mediation, which indicates that an amount of rupees 12 lakhs has been paid by the opposite party in the joint account of the petitioner and her mother, who are respectively the daughter and the wife of the opposite party, in connection with a mediation proceeding, in a one-time settlement, between the opposite party and his wife. It is submitted by learned counsel for the petitioner that the petitioner, the major daughter of the opposite party, in view of you are still unmarried, obviously. In view of still being unmarried, is entitled to maintenance independently from her father, the opposite party. Next para, since the petitioner, it is submitted, was not represented in the mediation proceeding, the award does not bind the petitioner. Next para, learned counsel for the opposite party raises an objection thereto by arguing that since by dint of the mediation, the amount of rupees 12 lakh was paid by the opposite party in the joint account of the petitioner and her mother, the petitioner is entitled to equal share in the said amount, and as such is not entitled to further amount of alimony. Next para, to this, learned counsel for the petitioner argues that the petitioner, that the mediation award does not specify as to what share of the amount is allocated for the petitioner. Next para, be that as it may, the petitioner, in view of the opposite party, seeking a copy of the revisional application, let the matter stand adjourned for the day and be
My lord, can you see the my lord last order?
listed for hearing before the regular bench.
Kindly, my lord, see the my lord
I have
last
jotted down for the next bench. I have jotted down the.
My lord,
problem.
kindly see the last order. My learned friend duly appeared.
My lord, I appeared.
My lord, last occasion, my lord.
On last
My lord, I
there
have
was an
my lord
adjournment, my
served the my lord.
No, my lord,
I have got a copy. Take it and have a photocopy. Next matter.
Item number 40.
My lord, this is my lord, very my lord, unfortunate, my lord, that my lord, one learned advocate, my lord.
Absolutely unfortunate.
And my lord, before puja, my lord, I am not getting anything, only 2,000, my lord.
You ask your mother to give 6 lakh out of the 12 lakh. You will get 6 lakh outright. Next. Yes.
May I
sir.
please?
Yes. What is your quantum in your? I'm dealing in lakhs now.
A suit for partitioner, there is a direction to serve and come back. I have served. One has returned with the endorsement as deceased, and
Take steps.
And
A learned counsel for the petitioner submits that the endorsement on the postal articles sent to one of the opposite parties as per direction of previous direction of court has returned with the endorsement deceased. Full accordingly, leave is granted to the petitioner to take appropriate steps for substitution of the heirs and legal representatives of the deceased respondent.
the only difficulty is that trial is proceeding.
Date persons. Accordingly, let the matter stand adjourned for the day and be listed before the regular bench having determination.
Item number 50.
File your application as soon as possible after the
Should
meeting.
I place this on record?
Acha, actor line, yes, because I have recorded. Ageta actor line add ko do, affidavit of service filed to be kept on. This is item, next one is item 16. 15. 15. Item koto daklen? 15 who is appearing? Item 15. None appears for the parties, adjourned for the day.
Item number 16.
16 minute, Mr. Sukanta Chakraborty is appearing for the petition.
I'll just adjourn for the day, Mr.
Lots.
Yeah. On the prayer of the. No, you are for the opposite party?
I am for the petitioner.
Achha, on the prayer of the petitioners, let the matter stand adjourned for the day. And be listed before the regular bench having determination. Thank you.
Item number 17.
None appears for the parties at the time of call. Full stop adjourned for the day and be listed before the regular bench.
Item number 18.
18 minute, I am for the petitioner. Opposite party is appearing in this matter.
Who is there?
Name.
Chakraborty means who?
Anusakta Chakraborty.
What should we adjourn it? You are enjoying an interim order?
Yes, I am enjoying.
Till disposal?
No.
Till when?
Till monthly step. Till end of November.
Oh,
end of December.
Oh, then it's none appears for the opposite parties. Let the matter stand adjourned for the day and be listed before the regular bench.
Much obliged. May I wish you also a happy Puja.
Same to you, Mr. Ghosh. Thank you.
Item number 19.
Not today.
Item number 20.
Same.
21.
I'm for the petitioner.
Petitioner?
Petitioner.
No caveat.
No caveat. This is for direction upon the court below for
expeditious hearing.
Lastly, coordinate bench was pleased to direct me to bring on record the certified copy, whether the opposite party has filed their. Yes,
Then.
2021 mat suit is pending. Opposite party taking time back to back for filing WS. They filed the put up. The fifth page, my lord, will get.
You are the plaintiff in the suit or defendant?
I'm plaintiff.
What is the suit for? Matrimonial.
Yes, my lord.
Divorce.
Since 2021, it is pending, my lord.
What is the stage of the suit? It has reached the peremptory stage.
No. Even the opposite party has not filed the WS.
Oh, no application is pending.
No, application under order 6 rule 17 is pending. That is on my behest. I have filed
so that has to be decided first then.
My lord.
So direct that to be decided within limited period and suit after that.
My lord.
The certified.
Order, my lord. I got it from the order that order 6 rule 17 application is pending. Fifth page of the. My lord, I am led by Mr. Fifth page, my lord, the last order. Order 6 rule 17 application on behalf of the petitioner.
The direction could be.
No. There is already an application pending under order 6 rule 17.
Good.
The certified copy of the order sheet of the trial court is filed in court today as per previous direction of a coordinate bench and is kept on record. For next para, learned counsel for the petitioner submits that the divorce suit filed by the petitioner has been kept pending for a prolonged period of about 4 years. For next para, it transpires from the order sheet that an application for amendment of the plaint under order 6 rule 17 of the Code of Civil Procedure is also pending at the behest of the petitioner. For next para, in view of the innocuous nature of the proposed order, prior service of notice to the opposite party is dispensed with. Full stop. CO number. আরেকটা line add করি. Since a matrimonial suit is urgent by its very nature, comma, an appropriate direction ought to be passed in the opinion of this court for expeditious hearing of the suit and the connected application. Full stop. Next para. Accordingly, CO 1538 of 2024 is disposed of by requesting the learned additional district judge, fast track court, 5th court at Barashat, North District, North 24 Parganas, to dispose of all applications pending before the said court in connection with matrimonial suit number 1944 of 2021 as expeditiously as possible, comma, preferably within November 30, 2025. Full stop. Thereafter, comma, the learned trial judge shall make endeavor to dispose of the suit itself at the earliest, comma, preferably within 6 months thereafter. No orders to cause urgent certified.
Grateful. Grateful.
Thank you. Yes.
Item number 22.
22.
Lordship, appearing on behalf of the petitioner.
Affidavit of service.
Lordship.
Good service has been effected.
Lordship.
Very well. What is the matter about?
Lordship, this is an expeditious.
Why did you serve? There was a previous direction.
Lordship. Lordship.
Achha, well. You have checked up good service effected.
Lordship.
What is the matter?
Lordship, this is an expeditious.
Use the microphone. It can't be heard.
I'm so sorry, Lordship. Lordship, this is an expeditious disposal. There was a suit pending for declaration and injunction against the defendant, Lordship.
What is the stage of the suit?
Lordship, the defendant not yet have filed the.
What is your name? Not your client, your name.
Lordship, Deblina.
Pardon?
Lordship.
Your name. You are looking in the records for your name.
No, Lordship, I am Deblina. Deblina De.
Deblina what?
De.
De.
Lordship.
I cannot say Miss Deblina. So
Lordship, I'm not the advocate on record.
you are appearing. You are the counsel.
Lordship.
Yes. What is the stage of the suit?
Lordship, this defendant had not yet filed the written statement yet.
When was the suit filed? 2023.
2023, Lordship.
No interim application is pending.
No, Lordship.
The present application has been filed for expeditious hearing of a suit for declaration and permanent injunction. Affidavit of service filed today be kept on record. Full stop. Despite service, none appears for the opposite party. Full stop. Next para. It transpires from the submissions of learned counsel. It transpires from the submissions of Ms. Deblina De, D-E-Y.
D-E, Lordship.
D-E. Deblina De, comma, learned counsel for the petitioner, that the suit is pending since the year 2023. Full stop. Next para. Ms. De submits that no interlocutory application is pending in connection with the suit. Full stop. Next para. In such view of the matter, comma, CO 1540 of 2024 is disposed of by requesting the learned Civil Judge Junior Division First Court at Barakpur, District North 24 Parganas, to dispose of title suit number 197 of 2023 pending before it as expeditiously as possible, comma, preferably within 1 year from the date of communication of this order to the learned trial judge. Full stop. No orders to cause urgent certificate. Thank you.
Item number 23.
Not today. Please order record করতে হবে.
Item number 24.
Yes, Mr. Ghosh.
For the petition, defendant petition, pursuant to earlier direction, 10, two of tag report said item delivered in respect of two opposite parties and one is
You are for which of the opposite party?
for two
Opposite party number 2.
two of the opposite, 2 and 3.
2 and 3 has been served.
Yes, ma'am.
1 has not been served.
One has been the article written with.
So then you have to serve again. Although the opposite party numbers 2 and 3 are represented through counsel, comma, learned counsel for the petitioner submits that
2 and 3, then my learned senior friend is appearing for the 3. 3's tag report he says. I mean, sir, car I
am leading him.
Sir, car appear.
you are leading him. Who has not been served, Mr. Ghosh?
Opposite party number 3.
3, you are appearing for 3.
No, we are not. Because
although some of the opposite parties are represented through counsel, comma, it transpires from the affidavit of service filed in court today by learned counsel for the petitioner that the Opposite party number 3 has not yet been served. Full stop. None appears for the said opposite party as well. Full stop. Accordingly, the petitioner shall serve a fresh copy of the revisional application on the opposite party number 3, indicating that the matter shall be listed before the regular bench having determination after the upcoming annual vacation, and file an affidavit of file a further affidavit of service on the returnable date before the said bench. Thank you. Happy vacation. I'll not be sitting after recess.